If you are an immigrant living in Florida right now, I need you to stop whatever you are doing and watch this entire video. Because the laws that control your ability to rent an apartment, keep your driver's license, run a business, or literally stay inside your own home changed faster between 2023 and 2024 than at any point in the last 2 decades. And I don't mean small technical tweaks that only lawyers notice. I mean sweeping, life-altering changes that are already affecting real people in real ways right now. Landlords are confused, and honestly, some of them probably should have read the law before they started making demands they had no legal right to make. Tenants are scared. Drivers are showing up to DMV windows with documents they've had for years and getting turned away like they showed up to the wrong party. And somewhere in the middle of all this confusion, a lot of immigrants in Florida are making decisions based on fear and rumors rather than actual facts, which, let me tell you, is the most dangerous place you can operate from. Fear without information doesn't protect you. It just makes you easier to take advantage of. This video is going to cut through all of that panic and give you exactly what changed, what it actually means for your daily life, and what your real rights are under both Florida law and federal law right now. Stay until the end because the last section on what to do immediately might be the most important 3 minutes of legal information you hear all year. SB 1718, the 2023 Florida law that started all the panic. The single piece of legislation responsible for setting off the most alarm across Florida's immigrant communities is Senate Bill 1718. Governor DeSantis signed it in May 2023, and it went into full effect on July 1st, 2023. This one law made sweeping changes across employment, driver licensing, healthcare, and law enforcement cooperation all at the same time, which is part of why it created such widespread confusion. When one law touches that many areas of your life simultaneously, it's very hard to know what actually changed and what people are just assuming changed because they heard something from someone who heard something from someone else. So let's go through it carefully. SB 1718 significantly expanded Florida's E-Verify requirements. Before this law, only public employers and businesses with state contracts had to use the federal E-Verify system to confirm that new hires were authorized to work in the United States. SB 1718 extended that requirement to all private employers with 25 or more employees effective July 1st, 2023. Employers who knowingly hire workers without running them through E-Verify now face fines of $1,000 per day per violation. That's not a fine that most small businesses can casually absorb, which means employers who comply with this law will stop hiring workers who cannot pass the federal work authorization check. That is a real and significant barrier for undocumented workers who were previously employed without that electronic verification step. The law also did something that genuinely blindsided a lot of people who had been driving legally and responsibly for years. Several states, California, New York, Illinois among them, issue driver's licenses to residents regardless of immigration status. Those licenses are real licenses issued by real state governments, and people have been using them to drive in Florida without any issue for a long time. SB 1718 changed that. It made it a third-degree felony in Florida for a person to drive using an out-of-state license if they are not authorized to be in the United States. A third-degree felony. Not a ticket, not a fine, a felony. That affected an estimated hundreds of thousands of people who thought they were doing everything right by getting a license from a state that offered one. They woke up one day and found out their valid out-of-state license had essentially become a criminal liability in Florida. There's also a healthcare provision in SB 1718 that created enormous panic in immigrant communities. And honestly, the panic was somewhat understandable, even though the provision was more limited than people feared. The law required hospitals receiving Medicaid to collect and report data on the immigration status of patients. When people heard that, a lot of them stopped going to the hospital entirely, including for serious conditions, because they assumed that going to the emergency room might trigger immigration enforcement. That assumption was wrong, but the fear was real enough that it was causing actual harm. The data collection requirement exists for budget reporting purposes under the Florida Agency for Healthcare Administration. The law does not authorize hospitals to report patients to immigration enforcement, but that distinction got completely lost in the community-level panic, and some people made medical decisions based on misinformation that could have genuinely cost them their health or their lives. Florida driver's licenses for immigrants, what the law actually allows. Let's be very precise about this because it affects a lot of people and the details matter more than the general headlines. Florida does not issue standard driver's licenses to undocumented immigrants. Under Florida Statute 322.08, anyone applying for a Florida driver's license must present proof of authorized presence in the United States. Acceptable documents include a U.S. passport, a permanent resident card, a valid employment authorization document, or a non-immigrant visa with I-94 documentation, among other options. If you cannot present one of those documents, Florida will not issue you a standard driver's license. That's the baseline rule, and it has not changed. But here's where it gets important and where a lot of people get the wrong information. DACA recipients, individuals granted deferred action for childhood arrivals, receive valid employment authorization documents as part of their DACA status. And Florida Statute 322.08 explicitly allows EAD holders to obtain a Florida driver's license. So if you are a DACA recipient with a valid unexpired EAD, you can legally get and renew a Florida driver's license. The license will be limited to the period of authorized stay shown on your EAD, which means when your EAD expires, your license expires too. You are not getting a permanent license. You are getting a license tied to your authorization period. But you can have one, and that matters. For immigrants on valid non-immigrant visas, student visas like the F1, work visas like the H-1B, H-2A, H-2B, or L-1, or even tourist visas like B-1 and B-2, Florida will issue a driver's license annotated with the expiration date of the visa. Under Florida Statute 322.17, the license automatically expires on the same date your authorized period of stay expires. This means your license is not automatically renewed when your visa is extended. Every single time you extend a visa, you need to go back and renew the driver's license too. A lot of people miss this step and end up driving on an expired license without realizing it, which creates a whole new legal problem they weren't expecting. What SB 1718 actually means for Florida landlords, and what most of them still don't know. One of the least discussed and most misunderstood sections of SB 1718 is what it does, and more importantly, what it does not do, to the landlord-tenant relationship in Florida. And here's the thing that will probably surprise you. The law did not create any direct requirement for Florida landlords to verify a tenant's immigration status before signing a lease. Zero. None. The Florida Residential Landlord and Tenant Act, which lives in Chapter 83 of the Florida statutes, does not list immigration status as a permissible basis for refusing to rent to someone or for evicting them. A private landlord in Florida is currently not legally required to verify a tenant's immigration status before executing a lease agreement. What SB 1718 did create, though, was a massive chilling effect. A lot of landlords, and probably ones who heard about the law secondhand, maybe from their cousin who heard it from a neighbor who half read an article online, started demanding social security numbers, passports, and immigration documents that went way beyond anything they legally needed to verify a tenant's identity or creditworthiness. And some tenants, not knowing their rights, handed over documents they had no obligation to provide or quietly walked away from housing they had every right to rent. Here's what landlords who did that need to understand and what tenants who experienced it need to know. Under the Federal Fair Housing Act, specifically 42 U.S.C. Section 3604, it is unlawful to discriminate in the rental of housing based on national origin. A landlord who refuses to rent to someone solely because they appear to be from another country, or who applies different and stricter documentation requirements based on a person's perceived immigration status, may be violating federal law. And federal law does not care what state law says when it comes to this. Florida's own Fair Housing Statute in Chapter 760 of the Florida statutes mirrors the Federal Fair Housing Act and is enforced by the Florida Commission on Human Relations. Tenants who face housing discrimination based on national origin can file a complaint with HUD within 1 year of the discriminatory act. They can file a civil lawsuit within 2 years. And critically, tenants do not lose these protections because of their immigration status. Renting in Florida without legal status, your actual rights as a tenant. This is the section I really want you to pay attention to, especially if someone has ever made you feel like you have no rights as a renter because of your immigration status. An undocumented person can legally sign a lease and rent housing in Florida. There is no Florida statute that prohibits a landlord from renting to an undocumented person. There is no statute requiring landlords to verify immigration status as a condition of tenancy. The Florida Residential Landlord and Tenant Act governs the rental relationship based on the lease contract itself, not on the immigration status of either party. This means undocumented tenants have the same statutory rights under Chapter 83 as any other tenant in the state. Your landlord is required under Florida Statute 83-1 to maintain the property in a habitable condition. That means keeping the roof, windows, screens, plumbing, and structural components in proper working order and complying with applicable housing codes. If the air conditioning breaks in a Florida summer and your landlord ignores you for 3 weeks, that is a habitability issue and you have the right to pursue remedies regardless of your immigration status. Your landlord doesn't get to ignore their legal obligations just because they think you won't say anything. Here's the one that really matters. A landlord cannot legally retaliate against you for complaining about housing conditions by threatening to report you to immigration authorities. Florida Statute 83.64 prohibits retaliatory conduct by landlords, and Florida courts have specifically found that threatening to report a tenant to immigration enforcement constitutes retaliatory conduct under that statute. If a landlord ever says something like, "Pay me or I'll call ICE," and yes, this actually happens, that statement itself is potential evidence of a legal violation. Document it. Write down exactly what was said, when, and in what context. Text it to yourself so there's a timestamp. That documentation could become important. If a landlord actually wants to evict a tenant, they must follow the eviction process under Florida Statute 83-6. Written notice is required. 3 days for non-payment of rent, 7 days for a curable lease violation, or 7 days without the option to cure for an incurable violation. If the tenant doesn't comply, the landlord must file an eviction action in county court. What a landlord absolutely cannot do is change the locks, remove your belongings, or cut off your utilities as a way of forcing you out. Those actions constitute an illegal self-help eviction under Florida Statute 83.67, and they expose the landlord to a civil damages claim of 3 months' rent or actual damages, whichever amount is greater. So if your landlord tries to throw your stuff on the lawn instead of going through the court process, and this also actually happens, they are opening themselves up to a significant financial penalty. ICE detainers and Florida law enforcement want what the 287G agreements actually mean. SB 1718 mandated that all Florida sheriffs and the Florida Department of Law Enforcement participate in the federal 287G program under Section 287G of the Immigration and Nationality Act. Before this law, participation was optional, and several major counties, including Orange County and Palm Beach County, had chosen not to participate. SB 1718 made it mandatory for all 67 Florida sheriffs. What that means practically is that if you are booked into a county jail in Florida for any offense, and I want to emphasize any offense, including a minor traffic charge, your immigration status will be checked. That is a significant change from how things worked before in counties that had opted out. If ICE places a detainer on you after that check, local law enforcement is now required under Florida Statute 908.104 to hold you for up to 48 hours beyond your normal release time to allow ICE to take custody. Florida Statute 908.111 also prohibits local governments from adopting sanctuary policies, meaning no Florida city or county can create any policy that limits cooperation with federal immigration authorities. This is fundamentally different from states like California or New York, where state law actually restricts the extent to which local police can cooperate with immigration enforcement. In Florida, that option is legally off the table for local governments. How deportation proceedings actually work in Florida. Deportation, officially called removal, is a federal process governed by the Immigration and Nationality Act. Florida state law can place someone into ICE custody, but the actual removal proceeding happens in federal immigration court. Florida has immigration courts in Miami, Orlando, and Tampa, all operating under the Executive Office for Immigration Review within the U.S. Department of Justice. When ICE takes someone into custody in Florida, they are typically transferred to one of several immigration detention facilities in the state, including facilities in Miami-Dade County, Pompano Beach, Moore Haven, and McClenny. Once removal proceedings begin, a person receives what's called a notice to appear, the formal charging document that sets out the factual allegations and the legal basis for removal. The person then appears before an immigration judge. They have the right to be represented by an attorney, but here's the part that trips people up. There is no right to appointed counsel in immigration proceedings. Unlike a criminal case where the government provides a public defender if you can't afford a lawyer, immigration court does not work that way. If you cannot afford an attorney, you generally proceed without one unless a nonprofit legal organization steps in to provide representation. This is exactly why knowing your rights in advance matters so much, because by the time you're in proceedings, navigating the system alone is extraordinarily difficult. SB 264, Property Restrictions for Foreign Nationals. Separate from SB 1718, Florida passed SB 264 in 2023, codified in Florida Statute 692.204. This law restricts the purchase of real property by individuals who are citizens or domiciliaries of China, Russia, Iran, North Korea, Cuba, Venezuela, and Syria. The restriction applies within specific geographic zones, within 10 miles of a military installation or within 5 miles of critical infrastructure like power plants, water treatment facilities, and seaports. A citizen of China purchasing a condo in downtown Miami that has no proximity to a military base or critical infrastructure is not directly restricted by the geographic scope of SB 264. However, Chinese nationals who are not U.S. citizens or permanent residents are broadly restricted from purchasing any agricultural land in Florida under a separate provision of the same law, regardless of location. Sellers who knowingly transfer property in violation of SB 264 can face a first-degree misdemeanor, and affected property can be subject to forfeiture proceedings. Real estate attorneys have noted that title companies across Florida became significantly more cautious after 2023, sometimes demanding additional documentation from buyers with foreign names or foreign addresses, even when those buyers are U.S. citizens or permanent residents, a practice that could itself constitute a civil rights violation under federal law. Here is the distinction that gets misunderstood constantly in community reporting. SB 264 does not restrict the rental of residential property. The law applies to purchases. An Iranian national can legally rent an apartment in Florida near a military base. The same person wanting to buy a condo near MacDill Air Force Base in Tampa faces restrictions under SB 264. Renting and buying are treated completely differently under this law, and conflating them causes a lot of unnecessary panic. Federal protections that Florida law cannot touch. This might be the most important section in this entire video, so I need you to really absorb this part. Certain federal constitutional rights apply to every person present in the United States, regardless of immigration status. Florida state law cannot override them, cannot reduce them, and cannot take them away. The U.S. Constitution applies to all persons on U.S. soil, not just to citizens, not just to documented immigrants, but to everyone physically present in this country. The Fourth Amendment's protection against unreasonable searches and seizures applies to you. The Fifth Amendment's right to remain silent applies to you. The 14th Amendment's guarantee of equal protection under the law applies to you. You have the right to remain silent during any encounter with law enforcement, including an ICE officer. You are not required to answer questions about your immigration status, your place of birth, or how or when you entered the United States. You cannot be legally punished for simply refusing to answer those questions. Now, Florida Statute 856.021 does require a person to identify themselves to law enforcement if they have been lawfully detained, so providing your name in that situation is a legal obligation. But providing your name and answering detailed questions about your immigration history are two completely different things. Children who are undocumented have a constitutional right to attend public school from kindergarten through grade 12, established by the U.S. Supreme Court in Plyler v. due back in 1982. Florida public schools cannot deny enrollment to a child based on immigration status. Florida Statute 1003.21 requires school-age children to attend school, and the enrollment process for public school in Florida does not require parents to provide any immigration documentation. A parent's immigration status is not a valid legal basis for denying their child enrollment. Emergency medical care is federally protected under the Emergency Medical Treatment and Labor Act, EMTLA, 42 U.S.C., Section 1395 DD. Any hospital that accepts Medicare, which is virtually every hospital in Florida, must provide emergency stabilizing treatment to anyone who arrives in their emergency department, regardless of immigration status or ability to pay. A hospital cannot turn away someone who is in active labor, having a heart attack, or experiencing a serious injury because they are undocumented. The data collection requirement in SB 1718 does not change this EMTALA obligation in any way. Notario fraud, the scam that's quietly destroying immigrant families in Florida. Whenever immigration law changes rapidly, but then in Florida's has changed about as rapidly as it ever has, and the fraud explodes in immigrant communities right alongside it. The most common scam right now is notario fraud. In Latin American countries, a notario publico is a highly trained legal professional with authority similar to an attorney. In Florida, a notary public is an administrative role that allows someone to witness signatures and verify identities. That's it. A Florida notary cannot provide legal advice, cannot fill out immigration forms, and cannot represent anyone before USCIS or an immigration court. The gap between those two definitions is where scammers live, and they exploit it deliberately and ruthlessly. These scammers set up offices in immigrant neighborhoods, use the title notario, charge significant fees for services they have no legal authority to provide, and then either disappear entirely or file paperwork so incorrectly that it actively damages the client's case. Florida Statute 454.23 makes the unauthorized practice of law a third-degree felony. Florida Statute 501.1375 specifically prohibits immigration consultants from providing legal services and requires anyone advertising immigration assistance to post a clearly visible notice in both English and Spanish stating that they are not an attorney and cannot give legal advice. If you walk into an immigration assistance office and that notice is not posted somewhere you can clearly see it, walk back out. That missing notice is your red flag. If you or someone you know has already been victimized by notario fraud in Florida, you can file a complaint with the Florida Bar at floridabar.org, with the Florida Attorney General's office, or with local law enforcement. You may also be entitled to a refund under Florida's Deceptive and Unfair Trade Practices Act in Chapter 501 of the Florida statutes. Please do not let embarrassment or fear of authorities stop you from reporting. These scammers deliberately target people who are afraid to contact anyone official, and they count on your silence to keep operating. Employment rights for immigrant workers in Florida, what the law actually protects. Even with SB 1718's E-Verify expansion creating new hiring barriers, federal labor law protections for workers do not disappear based on immigration status. The U.S. Supreme Court did narrow some remedies available to undocumented workers in a 2002 case called Hoffman Plastic Compounds v. NLRB, specifically ruling that undocumented workers cannot receive back pay under the National Labor Relations Act for work that was never actually performed. But that ruling was narrow and specific. It did not strip undocumented workers of all labor protections, and anyone who tells you it did is either misinformed or deliberately misleading you. Florida employers are required to pay all workers, documented or undocumented, at least the Florida minimum wage for every hour worked. Florida's minimum wage increases annually under Article 10, Section 24 of the Florida Constitution. An employer cannot simply refuse to pay a worker what they are owed because that worker lacks legal immigration status. Florida Statute 448.110 provides a civil cause of action for minimum wage violations, meaning an undocumented worker can file a lawsuit in state court to recover unpaid wages. The Federal Occupational Safety and Health Act also applies to all workers regardless of immigration status. And critically, if you are injured on a job site in Florida, your employer cannot avoid workers' compensation liability by threatening to disclose or actually disclosing your immigration status. Florida Statute 440.02 defines covered employees broadly and does not exclude undocumented workers from workers' compensation coverage. Florida courts have specifically found that undocumented workers are entitled to workers' compensation benefits for on-the-job injuries. Opening a business and banking in Florida as an immigrant. Here's something that genuinely surprises people when they find out. Undocumented immigrants can legally form and operate a business in Florida. Registering a business entity, whether that's a sole proprietorship, an LLC, or a corporation, with the Florida Division of Corporations under Florida Statute 605-201 does not require proof of immigration status or a social security number. Florida business registration requires a name, a registered agent in the state, and a filing fee. Thousands of undocumented immigrants legally operate Florida businesses under this framework right now. The more significant practical barrier is the federal tax identification requirement. To open a business bank account and properly file business taxes, you need either a Social Security number or an individual taxpayer identification number, an ITIN. The IRS issues ITNs specifically for individuals who need a U.S. taxpayer ID but are not eligible for a Social Security number. ITINs are available to undocumented individuals. And here's something that matters a lot to a lot of people. Using an ITIN to pay taxes does not constitute a report to immigration authorities. The IRS operates under strict confidentiality rules under 26 U.S.C. Section 6103 and does not share tax return information with immigration enforcement agencies. Paying your taxes with an ITIN will not get you reported to ICE. For banking, several Florida banks and credit unions accept ITINs for opening checking and savings accounts. This matters practically because operating any business entirely in cash creates serious safety problems and serious accounting problems. Community Development Financial Institutions, CDFIs, in your area often specialize specifically in serving underbanked immigrant communities and can sometimes provide small business loans without requiring immigration documentation. What you need to do right now if you are an immigrant in Florida,